Welcome back to US Visa News Hub. I am Mr. Burhan. Today I want to share a real case study with you, a story shared by an immigration attorney who handled a marriage-based green card case that shows you exactly how tough USCIS can be, exactly what kind of scrutiny real couples are facing in 2026, and exactly what it takes to fight back and win when the system tries to push you into an endless loop of delays. In this case, a marriage-based green card was eventually approved, and the client was also able to move forward with Social Security. But according to the attorney who shared this, USCIS did not make it easy, not even close. This was a long fight. So let me walk you through this entire story, step by step, chapter by chapter, based on what the attorney described. And along the way, I'm going to show you exactly what USCIS is really looking for in a marriage-based green card case, so that if you are going through this process right now, you know precisely what you are up against. Let us start from the beginning. The attorney's firm handled this client's marriage-based adjustment of status from the very first filing. Everything was going well on paper. The team gathered the evidence carefully. They built a strong, layered, bona fide marriage case, not just the basics, but real depth. They prepared the wife and her husband extensively for the interview, going over every possible question, every possible angle an officer might take. They walked into that first interview feeling confident, because the work had been done. But here is what happened. In the moment, under pressure, the husband got nervous. And nerves do strange things to people. He answered 3 basic questions incorrectly: which movie they watched on their first date, the full name of someone who attended their wedding, and a deeply personal question about their relationship and intimate life. Now, on paper, these sound like small mistakes, nervous mistakes, the kind of thing that could happen to any real couple sitting in front of a government officer with their entire future on the line. But USCIS does not always see it that way. Despite an extensive amount of documented evidence, they did not approve the couple after that first interview. A second interview was scheduled instead. And here is where the frustration really began. That second interview took 3 full months just to get rescheduled. 3 months of uncertainty, 3 months of waiting, 3 months of frustration, especially because this couple wanted to travel, and she had been out of status for a while already. But according to the attorney, make no mistake about it, this was a real marriage. They were living together. They were building an actual life together, day by day, just like any other married couple. They went back for the second interview, and this time, something changed. It was not just a USCIS officer sitting across from them. Another agent was present in the room as well. The attorney could not confirm exactly which agency this second person represented, whether ICE or DHS, but they were there, watching, listening. That alone tells you how seriously this case was being scrutinized. They went through every single question again, from the beginning. This time, every answer was correct. Not one mistake. And still, USCIS did not want to approve the client. That is the moment the attorney knew they had to bring in something stronger than just paperwork. They had to bring in case law. They laid out the shared finances. They laid out the shared assets. They laid out a life clearly, visibly built together. The one issue USCIS kept circling back to was how long the couple had actually lived together under one roof. So the attorney explained it clearly and firmly. Under immigration law, what actually matters is that a couple is living together as a bona fide married couple, not some arbitrary number of months or years that an officer has decided in their head is the correct benchmark. After that second interview, the couple was still not approved. USCIS said a request for evidence would be arriving in the mail. They waited. It never came. Days turned into weeks. Weeks turned into months, and almost 6 full months passed in complete silence. No update, no communication, nothing. So the attorney's team did not just sit back and wait, they took action on every front available. They filed a formal inquiry through the proper channels. They wrote directly to the USCIS Ombudsman. They spoke with a Tier 2 officer to try to get real answers. They even reached out to the congressman's office representing the client, because sometimes that kind of pressure is exactly what moves a stalled case. And still, the case did not move. It felt honestly like shouting into silence. But finally, after additional persistence and follow-up, they got a response. USCIS scheduled a third interview. This time they walked in with a different officer sitting across from them, and the team laid everything out on the table, exactly what USCIS looks for under the relevant INA statutes for a bona fide marriage-based adjustment of status. They proved, point by point, that the client was fully admissible. No criminal history, nothing hidden. They proved her husband met every single income requirement needed to sponsor her. And still, somehow, the officer was hung up on those earlier missed questions from the very first interview and kept coming back to the length of time the couple had lived together. This video is for informational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your case. The attorney made it clear to the officer, as respectfully but firmly as possible, yes, those discrepancies may raise questions on paper, but you cannot judge an entire marriage based on 2 missed answers from one nervous moment in one interview. You have to look at the whole picture, the full story. When did they actually meet? What is their real love story from the very beginning? What trips did they take together, big or small? What milestones and life events did they celebrate together as a couple? Birthdays, anniversaries, holidays? What financial decisions and investments did they make together? Decisions that only a real couple building a real future would make. The attorney pointed out very directly that even couples who have been together for 5, 8, 10 years sometimes get a question wrong under the pressure of a formal government interview. That alone does not make a marriage fraudulent. That is simply human nature under stress. The attorney also made it unmistakably clear that they were prepared to file a mandamus action if necessary, because based on everything that had been submitted, this couple was legally entitled to a decision, not indefinite silence. And they showed, clearly and with real evidence, that if she were not approved, her U.S. citizen husband would face genuine hardship if she had to leave and return to her home country to complete processing from abroad. In the end, the green card came through. According to the attorney, the client was relieved beyond words, and so was the entire legal team. It took real strategy, real persistence, and a refusal to give up when the case seemed stuck in limbo. This was a battle worth fighting, chapter after chapter, and in the end, it was a battle that was won. So here is what I want every single one of you watching this video to take away from this case study, because these lessons apply whether your case is easy or whether it turns into a long fight like this one. Number 1. You have to prove, beyond question, that you are in a bona fide marriage, and the bar for that proof has gotten noticeably higher. According to the attorney, USCIS is no longer giving much weight to the kind of evidence that literally any couple can obtain just by being legally married: a shared credit card, a joint lease, basic documents that require nothing more than a marriage certificate to get. Yes, these things still count as evidence, but they no longer carry the weight they once did years ago. What USCIS really wants now is your love story, in full detail. Where did you celebrate your anniversary, and who exactly was there with you? Where did you celebrate a birthday together? Where have you traveled as a couple? And it does not have to be some international trip. Even a weekend getaway to a nearby Airbnb counts, as long as you can show who was there and who witnessed it. Did you go through marriage counseling together? Do you have vehicles or loans registered in both your names, showing real shared financial risk? What kind of financial decisions and investments have you made together as partners building a life? It is 2026, and immigration officers want to see a fully bona fide, deeply personal marriage, not just a folder of paperwork. Expect detailed, sometimes uncomfortable questions about your relationship, your personal life, even your medical history together. And remember this above everything else: a green card is a benefit, not an automatic right. And this is exactly the level of scrutiny officers are now applying to every single case that comes across their desk. Number 2. Make absolutely sure every form is filled out correctly and consistently, front to back. Your employment history and every single detail on your paperwork should match, word for word, what you say out loud in the interview room. Your I-864 affidavit of support needs to be complete, accurate, and fully truthful, with nothing hidden and no misrepresentation anywhere in the record. And if there was ever a misrepresentation made earlier, at the original visa stage, now is the time to address it directly and honestly, not to hide from it and hope it never comes up. Number 3. Be fully ready to show your eligibility for adjustment of status from inside the country under current immigration law, and be ready to demonstrate, with real evidence, the hardship your US citizen spouse would face if you were forced to return to your home country to complete processing there instead. And finally, number 4. Whether it is husband and wife, wife and wife, or husband and husband, prepare extensively, seriously, and thoroughly for your interview. Do not walk into that room underprepared, because as you just heard, even a few nervous answers can send your case into months of unnecessary delay. This case study is a great reminder of what immigration officers are looking for in a marriage-based adjustment of status case in 2026. And now, having heard this entire story from start to finish, you know exactly how to prepare for your own. This video is for informational and educational purposes only and does not constitute legal advice. Please consult a licensed immigration attorney for guidance specific to your situation.